right. And then let's see. Okay. Our next case is Adams versus Adams. Ms. Powell, you're up.
Good morning. My name is Megan Powell. I'm here on behalf of the appellant, Alicia Adams. I'd like to reserve 3 minutes for rebuttal, and may it please the court. As I'm sure the court is aware, there are quite a few issues up on this appeal, but I think the most important thing to understand about this case is the cumulative effect of all the issues raised and how they affected Ms. Adams' due process rights and the propriety of the final judgment of dissolution. Because it is a vast appeal, if the court does have any specific questions regarding any of the issues raised, I'd be happy to address those in the beginning, but otherwise I'm just going to try to get through as much as I can and answer your questions as they come. All right, so we essentially have a case here with highly contentious parties, and having not been trial counsel and just dealing with the record, it seems like things got a little out of hand in the way that the trial court and the parties handled matters in the case. And I think the overall effect of that is that Ms. Adams was not permitted to present her case or be represented by counsel.
Well, Ms. Powell, Ms. Adams' counsel withdrew.
Certainly, yes, he did withdraw. And so I could for a moment just go to kind of how this all went, how this all occurred, because I think the order that it occurred matters. So we've got obviously the case at hand, and then the attorney eventually asks to withdraw. I think the motion to withdraw is in October of that year, and then for some reason it's not heard until December of that year.
So did Ms. Adams oppose his motion to withdraw?
I don't believe that the motion
indicates. I'm not aware that there was any, resistance on her part.
Right. I don't believe the record reflects.
So the judge knew that Ms. Adams had, at least from the time of the filing of the motion, roughly 2 months till the hearing date, correct?
Roughly until the hearing date. Yes, that's correct. So Ms. Adams' counsel asked to withdraw, and ultimately 2 months later, they go to the hearing on the motion to withdraw. The court allows him to withdraw, but just a few days before this hearing, there's been a motion filed to strike Ms. Adams' pleadings. So that's one major issue for allowing the attorney to withdraw as well. That's based on discovery violations that I don't think the record will ever be able to tell us whether that was involving Ms. Adams or her attorney's fault in terms of whether the documents were provided.
But we know there were at least 2 motions to compel, correct? Over that
yes, time. My understanding is that there were 2.
Contempt, right?
Yes, so and then the motion to compel was granted, and then later the motion for contempt was filed right before the motion to withdraw was heard.
Let me ask you a question about the striking of the pleading.
Certainly.
Generally, when someone's pleadings are stricken and they're the defendant or the respondent, as Mrs. Adams was here, that is followed by a default. Yes. There was no default in this case.
No.
She was allowed to participate at trial. I mean, you're going to argue she wasn't, but I mean, she showed up for trial. She started off, the judge was letting her testify. Right. And as I looked at her answer and counter-petition, there was really no relief that she didn't request that was not outside the scope of the initial complaint. Correct. So even if that answer and counter-petition were stricken and she wasn't defaulted, she still could have presented a case about everything that was raised in the complaint. In this instance,
I don't agree that she was permitted to present her case, and it's something I was going to address later, but I'm happy to address it now. I think
let me say this. You're going to argue that she was not allowed to present her case, but she wasn't not allowed to present her case because her pleadings had been stricken.
Well, it's a little bit of both. So the court
I didn't read it that way. I mean, she wasn't allowed to present evidence and documentary evidence because not because her pleadings had been stricken, but because she had not furnished the exhibits ahead of time like she was required to do.
Right. And I think that was something that this goes back to the motion to withdraw, and also to the fact that the motion to strike the pleading comes right before the motion to withdraw is granted. The attorney files the motion to withdraw. I can tell the court I did not see a single record instance where her attorney seemed to make any real filings towards providing her documents or anything. In fact, the one time that her documents were provided, she actually filed them, the thing saying that her documents had been provided. I think if the parties can agree on anything in this record, it's that Ms. Adams was not competent to represent herself and did not understand what it takes to represent yourself in court. I also think the record is clear that Ms. Adams wanted to be represented by counsel. I understand the idea that—
And if I may, Ms. Powell, and I think this goes back to the motion to withdraw was filed 2 months, correct? 2
Correct.
months before ultimately was heard. And if somebody, I would imagine that your client would be put on notice, oh, my lawyer wants to withdraw, I need a lawyer. She could have taken steps to try to get someone to get on board. 2 months is a long time. And so to wait till the hearing, doesn't she bear some responsibility to try to get somebody on board if what you say that she really, really wants to have a lawyer representing her? So that's a concern.
And I understand the court's position on that. I think, so what we're talking about now is going into the elements of whether the court should have granted the continuance. We're kind of not really at the withdrawal at this point, we're at the continuance argument. What the court is referring to is whether the reason for the need for the continuance was foreseeable to Ms. Adams. I think that candidly, that prong is probably met. I don't think it would be, I don't agree necessarily that the attorney filing a motion to withdraw makes it that a pro se who does not understand what's going on should automatically be put on notice that she needs another attorney. I also think we're at a disadvantage with the record because I don't know that she didn't go looking for an attorney. It was the holidays. The record doesn't seem to indicate one way or another whether she did or didn't. I do know that she found an attorney in the end who was willing to represent her. However, what the court is talking about here is just one prong of that test. So we've also got the idea of what is the injustice that the person is going to suffer if the continuance isn't granted. And then also what is the prejudice to the non-moving party if the continuance is granted. This is a balancing test that the courts consider. It's not where if you have one, you can't get a continuance if you have the others.
And also you have to factor in the standard of review, which is abuse of discretion. And this is an area, I think you'll agree, where the trial court has tremendous discretion.
I agree with the court. I just think that under the circumstances, looking at everything together, I think that, first of all, there had never been a continuance requested in this case. Ms. Adams was represented by counsel throughout the majority of the case, and her counsel had responsibility to her until the day that he withdrew, not from the day that he filed the motion to withdraw. I can tell you, I've never been in a case where we filed a motion to withdraw and the court was like, okay, you have no other responsibilities now, but I haven't ruled on it yet. So
well,
I think
we have no evidence that counsel wasn't fulfilling that responsibility. You are asserting it, but we have no evidence here of that being the case.
No, what I'm just saying is that it's more complicated than just there was a motion to withdraw filed and then, 3 months later or 2 months later, there was a trial. There's all kinds of considerations here, like, was Ms. Adams competent to represent herself? The case law that we presented to the court talked a lot about, in terms of the injustice suffered by the moving party, is this something they're actually going to be capable of doing on their own? There's also case law that suggests in family law cases that pro se is a lot more disfavored because you have things involving alimony.
And yet family law cases are probably the #1 type of case where we have pro se litigants.
No, and I understand. I mean, divorces are common and litigation is expensive. So, I mean, I'm not necessarily surprised that there's a lot of pro ses, but in a circumstance where you have a pro se litigant who I think in the course of the proceedings has demonstrated that she's not able to represent herself, who, albeit late, found an attorney who, and I think what the attorney was requesting is important in this as well. The attorney filed the motion to continue and requested, hey, I just got on this case. I'm willing to represent her. I need a short period of time to get acclimated. Maybe in that time we can try again with mediation. And then
is it clear that
the attorney didn't show up to argue that?
Well,
Correct.
The attorney noted in the motion that he wouldn't be able to. So he filed it on an emergency basis, like 2 days before the trial. Now, it was a late notice. I don't think anybody can in good faith argue it wasn't a late notice, but he noted in his motion that he wouldn't be able to be there. However, that's another major issue in this case, which is that even though the attorney wasn't there to argue it, the court didn't allow Miss Adams to present the motion either on her own behalf. So,
and if I may, Ms. Powell, I think you said earlier that the lawyer was ready to represent her. I think, didn't he file a limited notice of appearance? So there's really nothing based on this record that he was planning to take this case on, at least from what I'm seeing here in the file.
actually, I disagree with the court. The limited appearance, when read on its own, appears that he's only there to argue the motion to continue. However, the motion to continue sets forth all the information about how he just got on the case, he needs time to acclimate, he'd like to mediate, and he expects to represent her at the trial in just a few short months. So if you take the limited appearance
No, that expectation, but it's not like I've been retained, I will do this, I will do that. So just on this record alone, I think you're coming to the conclusion that he's definitely going to do that. I've read that, and it just gave me a pause that it wasn't as definitive as you make it sound to be.
I can check very quickly the language of the motion to continue in the record. I'm not sure that it was as vague as that. I candidly don't remember the exact language that he used, but he did say respondent hired the undersigned counsel on Wednesday, January 18th under a limited appearance. And then he just says he hasn't had an opportunity to review the file or pull up any documents. So he doesn't, and he needs documents as well from opposing counsel to prepare to represent her throughout the remainder of the case. And then he says he needs additional time to fully conduct discovery, to take depositions, to prepare for the final hearing in this case. So I don't necessarily agree with the court that he was vague in what he was saying, that he was maybe going to represent her. I think he had a solid plan in mind for the steps that were going to occur after the representation. But whether the court agrees...
And I guess what I focused on, why would he put in his first paragraph, limited appearance? Limited appearance, that means for just something beyond like a full appearance. But I don't want to belabor the point. I know you have other issues that you want to be able to discuss, Ms. Powell. So why don't you go ahead and address some of these other
thank you. I
issues.
appreciate it. And I understand the court's concern. The next problem, like I touched on briefly, I was going to transition into, once we actually get to the trial, Ms. Adams tries to present her motion to continue, and the court doesn't allow it. In fact, the court makes a comment that a motion is nothing unless it's heard, and your attorney isn't here to hear it. And she doesn't allow Ms. Adams to present anything, and then she looks over to Mr. Adams' counsel and says, "What's your prejudice?" So she presupposes a prejudice and doesn't allow Ms. Adams to present the motion to continue, to maybe give an explanation as to why it took her so long to get an attorney, answer any of those questions.
And from the judge's perspective, isn't arguable that, you have a motion filed by an attorney, but the attorney who has filed an appearance for the purposes of that motion, but the attorney is not there.
I apologize. Can you repeat the question? I'm not sure.
The attorney didn't show up to argue it. I mean, wasn't that the judge's point?
Perhaps, but the pro se litigant is still legally permitted to argue her own motion. And I think if there's a motion that everyone's agreed they received and the court put in the docket that she would be hearing it that day, whether the attorney is there to argue it or not, to not allow the movement to argue the motion, but then to allow the non-moving party to argue their opposition, I think is a major problem. It's a due process violation because she has a right to be heard. I think under these circumstances, especially when we're dealing with a pro se who later we can tell from the record didn't understand how to represent herself, and the implication of the fact that this is to get an attorney who she has hired to represent her in this matter, even if the court's going to deny the motion, I think the court is required by the Constitution and by our laws to hear her out on the motion to continue that's been noticed and set to be heard that day. So to just ask what the opposition is and not actually allow Ms. Adams to present her continuance motion, I think is a major problem. Then we get to what actually happens in the trial court, which, I mean, this is one of those circumstances where the court has made a decision, whether you agree or not with the decision, to make her represent herself pro se in the trial when she had an attorney that she wanted to represent her, right? Obviously, she would have needed the continuance, but I'm just going off the assumption that she gets the attorney, they go to the final hearing 2 months later, and she's represented. The effect of not having the attorney there is that she has to represent herself, and she clearly doesn't understand how to do that. The record indicates that she didn't understand the implication of the denial of the motion to continue, and she certainly didn't know that her pleadings were struck. In fact, going very briefly back to the striking of the pleadings, even if the court were to find that the striking in and of itself was, I guess, supported, or I guess my point is this. The hearing for the motion to strike was not adequately noticed. The notice didn't include the Zoom information, and it didn't note that it was evidentiary. Then when the court entered the order on the motion to strike the pleadings, that order wasn't entered until after the trial. There was no written order in the record. And then
Ms. Powell, I hate for you to spend all your time on that. I went through and I tried to figure out what the ramification of the striking of the pleadings was on Ms. Adams, and I couldn't find any. She wasn't defaulted. She had no affirmative claim for relief in her counter petition that was precluded from her addressing in response to the petition. So, and her exhibits were excluded, not because her pleadings were stricken, but because she had not furnished them. They had not been furnished to the other side. So I hate for you to spend all your time on the striking of the pleadings when I frankly don't see any harm she suffered.
I think the harm doesn't come from just one thing in this case. It comes from the cumulative effect of everything. We've got.
I don't think the effect of anything was harmful to her in the striking of the pleadings.
Okay, well, I don't understand the court's position on that. I'll just move on if the court's inclined to hear.
Yeah, because you're going to run out of time, and you have a lot of other points that you probably want to touch on.
So she's at this hearing. She's not sure how to represent herself. You can tell from the record that she doesn't understand how to make legal objections or how to respond to opposing counsel's legal objections. She doesn't understand how to cross-examine. I think going back to the case law we were talking about with the continuance and allowing a pro se, even on the eve of trial, which is a case that I can pull up the case name, but there's a case we provided where the pro se litigant on the eve of trial asked for a continuance to get counsel, and the court was highly convinced by the fact that the litigant would not have been able to represent himself in that case. I think that's a clear area in this record that Ms. Adams wasn't able to represent herself. Then we get to, I think, what's the most important area on this appeal that I think—
One of the problems now, Ms. Powell, is you're getting to this area and you are down into your rebuttal time at this point.
That's okay. I'll be brief with it and I will cede some of my rebuttal time.
Right.
Obviously, we have the issue with the break in the middle of the trial. So the trial starts at 9:05 and ends at 11:20, right, per the court reporter's transcript. Somewhere in this time towards the end, the court calls for a break without the parties requesting a break. The record does not indicate how long the break was supposed to be. The parties went for a break, and when they came back, it appears from the record that Ms. Adams did not immediately return.
It appears from the record that they looked all over the courthouse for her. So even in the ladies' room, and they could not find her, and she didn't come back at any time during the remainder of that hearing.
But the remainder of the hearing was likely in the region of 20 minutes, and the break happens around lunchtime. So ultimately—
I didn't say she was breaking for lunch. I forgot what she said exactly, but as I read it, it seemed to me that she was saying, she's going to take a break for a few minutes.
The court didn't actually say anything about the reason for the break on the record. Of course, I wasn't there. Yeah. But it's one of those things where she leaves her belongings there, and then the court says she sounded the halls and that they waited for her. They didn't say how long they waited to come back. And then they essentially concluded the trial without her.
And they addressed it again. I mean, the bailiff, she's asking the bailiff again. The bailiff, when the trial resumes, at some point the bailiff comes back in and the judge says, "Have you found her yet?" I mean, they're still looking for her the whole time.
I disagree with the court. I don't disagree that they looked for her on multiple occasions. What I don't agree with is the idea that they thought that she wasn't going to come back. All of her stuff is still in the courtroom. The court acknowledges that she left her belongings there, and even at the end leaves a notice of hearing with her belongings, expecting Ms. Adams to come back. The trial is set from 9 to 5 p.m. and the break.
So come back, put yourself in the judge's shoes or anyone's shoes. She has gone. No idea where she is. How long are they supposed to wait?
I mentioned this in the brief, and I think that one of the things, just from a standpoint of a practical standpoint, obviously, I think no one can expect the court to wait all day long, right? I think if this had been a scenario where the court had said, Miss Adams hasn't returned, we were gone for, I don't know, 10 minutes. It's 11 o'clock now, let's break for lunch. Bailiff, if she comes back, let her know we're coming back at noon. If she's not back, then we're done. It's a 9 to 5 trial. And I know that there's not an authority for this. This is kind of more of like, what would you practically do as the judge? But I think we've also got to remember here, whether we agree that the continuance should have been granted or not, Miss Adams is a pro se at this point, and she's not a voluntary pro se. She's been required to be pro se because her attorney couldn't be there to represent her. She doesn't understand. Now, we're at a disadvantage with the record. I don't know what the reason for the break was. Nobody articulated when they should come back on the record. So it's hard, but I think under the circumstances, it certainly, I think at a minimum, would have been when the court is making a record that the court knows she's coming back.
But we're pretty sure she didn't just go to the ladies' room and then come back.
Well, I doubt it, but I don't know.
Well, I mean, actually, they actually looked there, but the case continued after the judge came back, and they went through this whole thing. Where is she? Where is she? Blah, blah, blah. And then they continue, and she didn't come back the whole time.
Well, the problem is when the court says the whole time, I don't know what the whole time means. And
the whole rest of the hearing, she didn't come back.
Right, the whole rest of the hearing, which I don't know, it could have been any amount of time. I realize I'm running out of time, but I do just want to
already run out of time, but I'll give you a little time on rebuttal, but you need to stop now.
Okay, no worries. Thank you.
Okay, thank you, Ms. Powell. Ms. Sultanfuss, you're muted. You're muted. I do this all the time.
Thank you. Sorry. Sarah Sultanfuss representing the appellee, Matthew Adams. May it please the court. I would like to correct some of what was indicated previously. The motion for the attorney to withdraw was filed on October 17th. That was 3 months before the trial. So she had 3 months notice before the trial that he was withdrawing. Unfortunately, this record has holes in it. The case was following the dependency case that had been with Judge Babb for some 3 years at the point that we were at the final hearing. In this case, there were hearings going on in the dependency case at the same time that these hearings were happening in this case, and unfortunately those records didn't make this record on appeal. There was in fact a hearing on—
And sorry, I'm curious about the timing, and I looked at it, and I don't really remember it all that well. But the dependency case was, the supervision was terminated. I read like right around the same time that the petition for dissolution was filed.
It was, but in fact, Mrs. Adams filed a motion for contempt and enforcement in that case during
in the dependency case.
Yes.
So after the divorce, but that's not reflected in this.
Well, there's portions of it that are reflected in the record. There was a hearing on, there was an initial hearing set on her motion that she filed for contempt on August 30th. There was a hearing
in the dependency case.
In the dependency case.
Okay, but we don't have that before us.
There is a notification in the record that was part of that dependency case because the cases were consolidated, which is another thing that's not reflected in the record as it should be. The cases were consolidated. We started out in the divorce case with Judge Nage. Then once she filed to reopen the dependency case, there was a motion to have Unified Family Court assume the divorce case, which is probably the way it should have been from the beginning. So that happened. So there was the hearing on the 30th. It was the motion hearings were continued, and as part of that notice, it was also noticed that any pending motions in the divorce case would be heard by her at the same time on the 24th. She was noticed through counsel to be there on the 24th. She did not appear. Her counsel did appear. Her motion was denied because she wasn't there to offer any testimony in the dependency case. We also filed a motion to have the court address some issues with the dependency case, but we withdrew at that point in time. Her attorney appeared and was heard on both motions to withdraw. Both motions to withdraw in the dependency case and the dissolution case were granted on October 24th as part of that dependency case. The order was never presented to the judge to sign, withdrawing, so that when we appeared on December, the following hearing, I believe it was December 19th, when we were there for pretrial, that's when Miss Adams did show up. Her attorney, it was a Zoom hearing. Actually, it was originally scheduled to Zoom, but we were there in person. Her attorney was trying to appear via Zoom and wasn't let in. He came in at the very end to address the issue that the order withdrawing him that had been heard and ordered back on October 24th hadn't been signed. So at that point in time, he submitted that order for Judge Babb to sign, which is why this record reflects that it wasn't signed or heard until December 19th. And that's not what happened. He came in at the very end realizing, oh, I haven't submitted this order. It hasn't been signed. I'm still on the hook for this. I need to get this done. That was it. That was all that was done from his perspective to withdraw. So he filed his motion on the 17th of October. It was heard on the 24th. She had 3 months of advance notice of not being represented and needing to have an attorney. There is a letter in the record that she sent to Judge Nage on the 27th of October, clearly acknowledging that she's not represented and asking him to look at something. I would also argue that there's no evidence that she was not competent to represent herself. She's an intelligent woman. She's worked as an intelligence agency with the Department of Defense. She was employed. All of these things are in the record. She was a competent person.
Can we skip? I mean, all of this is kind of a amorphous mess, but can we skip to some of the more tangible aspects of the case, like the ruling on, like, you know, the child support, setting the child support,
Yes.
setting the child custody issues?
Yes. So I certainly would agree with the court that there was no harm in the striking of the pleadings, and the result of her discovery or whatever evidence she had not being allowed in was the fact that she hadn't provided any of it ahead of time. I also would submit that in the end, she got everything that she would have been entitled to, even with the striking and even with her
all of her issues were addressed, because anything that she raised in her counter petition that was stricken were addressed in the final judgment.
Yeah.
And at the hearing.
So
Correct.
even after a motion,
if I may, Ms. Silter, because to try to, I know we're going through a lot of different
Right.
things. Would you help me focus on the imputation of income
I mean, I wouldn't
issue?
have that as well. Yeah.
so
Yeah, if you could just focus on that for me.
well, the one difficulty that occurred during the trial was that she left and never came back. She had basically abandoned the trial. There was no opportunity for me to cross-examine her on some of those issues. I recognize what is required in the way of findings, but the court can only make findings based on the evidence that was presented. She didn't present any evidence
Well, yeah, but I want to focus on what the evidence that you presented, Ms. Sultan.
Okay.
But, I mean,
Absolutely.
you know, the evidence that there were, I think, he testified that she had a job before, and that she lost, I think, or just before they separated. Is that
Right.
correct?
Yes, the
And
parties.
the separation was in the middle of 2020.
No, January of 2020, the very beginning
January
of 2020.
Was the
is when they
separation.
separated. And she was working, she had taken a job in North Carolina in the fall. I believe she was there through October, maybe the beginning of November. She had the job in North Carolina. She had one of their children with her for a period of time while she was working there. She was
But at that point, that was 3 years before the final hearing.
That was 3 years before the final hearing, but that was all of the information that we had. So during
But
the
did you
2
take her
years,
deposition during the case?
did not take her deposition.
Okay, and then he also had an email that said she'd been offered a job, I think, in 2019. So
Yeah, there was just prior, same time frame, she was offered 2 different jobs within that same.
but 3 years before.
Well, it was 2020. The trial was 2022.
I thought the trial was 2023.
January, beginning,
January 23.
right, January of 23, that's right.
Right. So 3 years.
So during that period of separation, but in that time frame, she never provided any discovery showing whether she was employed, underemployed, or
Got it.
anything.
I get it, but I think isn't the burden on you who's seeking to impute income? Don't you have certain the stat? I mean, 6130 talks about what you do if someone doesn't furnish information.
Right, and I think that that's what I did through his testimony and through the evidence of the job offers that she received. I think, and through his testimony that the family relied on her income for 55%
up until the separation.
Up until separation, but
Which
no other information was ever provided after that. Other than her testimony that she had a business that she was running at a $40 million loan that she had received.
But we don't know what her take from that business was, whether what salary she might have been drawing.
Right. We had no.
If I may, to follow up with that. So I know the imputation, we all know what the case law requires. Are you taking the position, Ms. Salton-Foss, because of her failure to provide records to you regarding whether she's employed, whether she's not employed, failure to provide discovery, which then caused the striking of her pleadings, the fact that nothing was submitted, that with this factual background, that relieves you or your client from the obligation of providing any evidence regarding her imputation of income, that the only thing that you have is the stuff that happened 3 years before. Is that what I'm hearing you argue?
I think I have to agree with that because our hands were tied. We had no ability to provide any other,
but except maybe perhaps take her deposition.
Perhaps, or to have her testify. My intention was on cross-examination to get into some of these issues, but she never came back.
You didn't call her in your case in chief.
I did not. I did not. So, you know, in regards to those things, I think that's pretty clear. And we haven't really gotten into the issue much on the motion to have the judge recused. I would like to say, I think there's evidence in the record that the judge really tried to help her work through some of these things. I don't think there's any record of any bias or any prejudice. I think the judge was very patient with her. I think that, you know, I don't know what was in her mind. I don't know what she was thinking, why she didn't come back. And another interesting part of it is that there was never any explanation for that. They filed a motion for a new trial. They filed a motion to have the judge recused. We've gotten to this point and there's never been an explanation offered other than, you know, she was trying to stop the trial. I think she had an agenda and she wasn't going to take no for an answer. So she left and she never came back. We don't know when and if she ever came back. And then there's no evidence to show that she came back and provided a reason for her disappearance.
Did she appear? I don't recall whether this was discussed or not, but the judge set a subsequent hearing to discuss the final judgment.
She did, and she did not appear for that.
Did she personally appear there? Did she have an attorney appear for that by then?
She did not. The attorney that filed the limited notice, Mr. Hurwitz, was noticed. Miss Adams was noticed of that hearing through. And
there was a note left to her. I know there was a note left for her about it on her belongings. And did she receive like a formal notice? Sent a formal notice?
Yes, from my office. Yes,
okay.
She did, and she. And did not appear once again. There was no response to any of that. And again, and no explanation. She just didn't come back. So, you know, I understand the court's questions regarding the imputation of income. And I think that might be, you know, an issue to.
And I have some concern. I mean, I know, you know, you were doing the best you could under those circumstances, but we know that Ms. Adams was having a pretty severe substance abuse issue, alcohol or otherwise. And we know that from the dependency. And we don't have much in the way of the dependency in our record, but we do have the final the order that terminated supervision, and we do have a reference to her being unavailable for a hearing because she was in a rehab facility. Given that, would you agree that it would be of substantial concern, where the court might wonder whether her ability to earn was the same 3 years later as it was when, she had the job before the parties separated?
Yes, I certainly appreciate the court's concern on that. However, I don't know how we could have handled it any differently. I think the case law and actually the statute require that there be some imputation of income, that child support is
the
right
court
of
did
child.
not make the court didn't make a formal finding, and this is what it's always I found it interesting about the imputation issue. The court didn't make a finding that she was voluntarily unemployed or underemployed.
No, because the court didn't even know whether she was employed or
Correct.
underemployed. We didn't know she
Correct.
was making $1 million a year or nothing. We didn't know.
Right. So this imputation was not an imputation based on under or unemployment. It was based on the court's deduction about what her income was based on what it had been 3 years before.
Well, I think it was based on her ability to earn. And I think that's important.
Yeah. Well, it's interesting. It's interesting. And now we're talking about angels on the head of a pin. Ability to earn is really a alimony issue. Ability to earn but not earning or underemployment is a child support issue. But she didn't make the determination that she was under or unemployed. She just determined that. Yeah, I get it. So
yeah, typically what would happen, the court would determine that you're capable of earning at least minimum wage if in fact you're not working.
Right. Or I think it's a little different now, not specifically minimum wage, but it's maybe a little higher. It's like government record, government, whatever.
So I think the court went on, all the evidence that they had, which was limited. So
I get it. And it's sort of related. No one moved in the dependency, as far as we know, to modify that child visitation or parenting order in the dependency order.
Never.
Correct?
No, that never.
And that wasn't a modification of that was not pleaded for by either party in this case.
No, never.
But we know that one of the reasons for that, that dependency order, placing sole custody with Mr. Adams and severely limiting her contact with the children, was based on her dependency issue.
Yes.
Which for our purposes, at least as a matter of record, we're still ongoing, at least legally, because there was no suggestion that should be modified.
And that certainly is my understanding of the law, that all of the issues that she raised in regards to being denied, an opportunity to address the factors, et cetera, was addressed by the judge multiple times throughout this case, but specifically in the pretrial order, indicating that that is not an issue that's going to be addressed at this trial, that it's been decided in the dependency case and the proper. And
she had heard the dependency case.
Yes.
Right.
Yes.
But the concern, again, that I think that concern is kind of interrelated. That fact is sort of interrelated with the concern about her ability to earn. If there's been no suggestion that her situation has improved to the point that she could have more contact with the children, that's the same issue that might affect her ability to earn.
Right. Other than her testimony that she's running a business and
that she started a business and got a loan. But yeah. Okay.
So
I get it.
All right. Thank you. I think that's
Thank you, Ms. Lopez. I appreciate it. Okay, Ms. Powell, I'll give you 2 minutes. How's that?
Thank you. I'm a little confused because so much of what we just heard and the argument we heard is all matters that are completely outside the record. I can appreciate that Ms. Sultan-Fuss was on both cases in the trial court, but as an attorney on the appeal who wasn't there, I can only deal with what's in the four corners of the record. One of the things that I heard that the court brought up that I thought was interesting was, or that was good to talk about, was something where Ms. Sultan-Fuss didn't call Ms. Adams in her case in chief to talk about the imputation issue. I think knowing how, considering Ms. Adams is representing herself pro se, and she has to kind of either, you know, she has to object to the other side and give her testimony on her own when it's her time in her case in chief. I think given the fact that you've got both people there, I think is actually essential the idea that instead of trying to gather evidence from the other side about imputation, she had the opportunity to ask Ms. Adams about.
But in fairness, Ms. Powell, isn't that a strategic thing? And having sat in family court, that sometimes lawyers do not wish to do that. They wait to proceed with cross-examination because they could proceed with, you know, with doing that. And in all fairness, no one expected her to take off. And I think that's the issue here. And I know when the court took a break, the court didn't say, I'm taking a luncheon break. The court said, we're staying in recess, we'll take a break. And you'd expect the attorneys or the parties to wait until the break is over to be on standby. And the fact that they could not find her, so with it being strategic, it doesn't really require them to call her and case in chief.
No, I
Isn't that-
agree that I agree it's a strategy decision. I think it's not as much of a strategy decision not taking her deposition at any point during the proceedings. I think not knowing what that, not even seeking that information. I also think we keep ignoring the fact that she's represented through counsel through most of this case. She has an
Well,
attorney.
and, you know, and, but in fairness, I mean, you know, they were making the discovery requests that were not being honored. So
I
mean,
agree.
it's not
I
like
just
they
don't.
didn't keep her financial information. And somewhere there is a financial affidavit from her in this record. I don't know what the context was.
Right. She filed
It's
her
kind of
own.
it's kind of floating. It's a bizarre one, frankly.
Right.
But
Again, she doesn't know what she's doing. She files a financial affidavit. I find it extremely important and interesting that the attorney in all these motions to compel and everything that's occurred in the motion for contempt, the attorney never filed any opposition or did anything to indicate that he was addressing the matter. From the motions to compel themselves, the motions state that Ms. Sultan-Fuss tried to communicate with the other side and that no resolution was reached. Unfortunately, that doesn't tell us whether she was able to reach the attorney or what the attorney said, but I think this is one of those situations where Ms. Adams is being held responsible for things that I think she has an attorney who has a duty to her to be representing her throughout this case. He also has duties to make sure that her.
If I may, Ms. Pop, and you don't know what was discussed between her and her attorney. It may have been a mutual decision. It may have been, we don't know all that. All we could proceed with what's in the record. So
Right.
this is what we need to stay focused on what's in the record.
and
Right.
we need to wrap this up because we're now well beyond your.
Okay, if I could just say one more
One more thing, and then that's it.
I know that's okay. I appreciate it, and I appreciate your time. I just think ultimately, when you look at everything that occurred in this case, all of the circumstances, this is really a matter of what Ms. Adams was put through and whether the proceedings were fair. And I think the record reflects the proceedings were not fair, and there was a due process violation. So that's how I'll conclude.
All right, great. Thank you both very much.
Thank you so much.
In order to leave our virtual courtroom, there's a button on your screen. It's called Leave. It's in red, and you click that, and you'll go off into the ether. And we'll think about you.
Have a good day.
You too. Okay, the court will be in recess for 10 minutes.